Welcome to our session. My name is Suzanne Hale. I'm the Registrar Collections Manager at the Gregory Allicar Museum of Art at Colorado State University. We're going to begin with our Deaccessioning Experts Legal and Ethicals Rationale panel. I'd like to first give you an overview of our session. We'll be talking about topics and goals, opening remarks. We'll have some moderator questions. We'll have audience questions. And then we'll have a closing question from our three panelists. This session is designed to help attendees understand the legal and ethical rationales regarding deaccessioning and to clarify misconceptions. Our session topics include museum governing boards, public trust, accounting standards, misconceptions, and recent controversies. We hope by attending this session, you'll be able to better articulate the ethical arguments for and against deaccessioning, as well as learn about some of the associated legal aspects. We want to help you recognize common misconceptions, and I hope that we all can gain insight about recent controversies involving deaccessioning and the use of funds from the disposal of deaccession collections. The information provided in this session is educational, does not constitute legal advice, and should not be construed as legal advice or legal opinion. I want to begin briefly with a statement from the AAM Code of Ethics regarding collection disposal. We should all be familiar with this, as well as other similar statements from museum organizations. Disposal of collections through sale, trade, or research activities is solely for the advancement of the museum's mission. Proceeds from the sale of non-living collections are to be used consistent with the established standards of the museum discipline, but in no event shall they be used for anything other than the acquisition or direct care of collections. A few years ago, AAM put together a task force to define the term direct care. After a great deal of work and research, the following definition was published in AAM's Direct Care White Paper. Direct care is the advancement that enhances the life, usefulness, or quality of a museum's collection. Even though we have clear statements and guidelines, controversies and problems over museum deaccessioning still continue. So today, we've called in the forces to help us understand what is happening and to provide us with some direction. I'm pleased to have three extraordinary experts on the subject of museum deaccessioning with us today. One of the harder tasks I have had was putting the session together was reducing and condensing their accomplishments into a few bullet points. So please know that you're only hearing a snippet about each of them. They are all very kind, approachable, and willing to share their expertise. Thank you for being here, John, Stephen, and Mark. After a brief introduction from me, each panelist will make an opening statement on our topic. First, we have John Simmons, who is simply one of the smartest people I know. If you play Trivial Pursuit, you want him on your team. Knowledgeable, creative, author, writer, excellent mentor and teacher, currently serving as a collection stewardship chair. John Simmons is president of Museologica Consulting and the adjunct curator of collections at the Earth and Mineral Science Museum at the Art Gallery at Penn State University. His books include Foundations in Museum Studies, Evolving Systems of Knowledge, Museums, A History, and the Registrarial Standard, Things Great and Small, Collection Management Policies. John, you have a few minutes to address our topic.
Thank you. What you will hear presented today comes down to two opposing arguments. One is that there are no laws that prevent a museum from selling deaccessioned objects and using the proceeds of those sales in any way that supports the museum. The second is that there are ethical standards that say that proceeds from deaccessioning should be used only for the acquisition or direct care of the collections. So, Just what is the difference between laws and ethics, and which should take precedence? The law is a system of rules established by a government entity that regulates the actions of members of the community and that are enforced by the imposition of penalties. But by contrast, ethics are standards of conduct. These are developed and adopted voluntarily by members of a profession to uphold the integrity of the profession. By definition, professional ethics require a standard of behavior that is higher than the law. If all that was required to be a professional was to obey the law, professional codes of ethics would not be needed, and museum work would be no different from any other job. The lack of legal restrictions on the use of proceeds from deaccessioning does not mean that it's okay to use those deaccessioning proceeds for whatever a director or a board wants to use them for. Rather, we have a duty as museum professionals, directors, and board members to adhere to the standards of the profession, which require us to use deaccessioning proceeds only for the acquisition or direct care of collections. Just because something is legal does not necessarily mean it's the right thing to do. What sets professional practice apart is our recognition and acceptance of the professional ethical standards that we have developed for museum practice.
Thank you. I was told by a legend in the collection management field that Stephen Urice was the best person she had ever heard address the topic of deaccessioning. Professor of Law, Arts Law Track, Graduate Program in Entertainment Law and Sports Law, University Miami School of Art. He served on the faculty and planning committee of the American Law Institute's course of study, Legal Issues in Museum Administration. He teaches art, museum, private foundation, and trust and estates law. He's a former museum director and foundation executive, which affords him a broad and extensive perspective on our topic. He has come to this conference exclusively to present in this session. So Stephen, will you please share a few opening remarks for the attendees?
Suzanne, thank you. This on? Yes. Thank you, and thank you for inviting me to join the panel. Among the many issues that deaccessioning stimulates conversation, there's one that is almost always overlooked. In fact, there's a new book that has just come out. I had it on the table a moment ago on deaccessioning, just came in the mail the day before I got here, and there's not even a mention of this issue. And that is the accounting implications. Now, I sympathize with those of you who came for a panel on deaccessioning at 8:45 in the morning and now suddenly learn you're going to have to hear something about accounting. It's not a lot of fun, but it's extremely important. And when we get into matters in a moment, we'll get into more detail, but in brief, the organization, the nonprofit organization that promulgates accounting standards that are used by privately held, publicly held corporations and the not-for-profit sector is an organization in Norwalk, Connecticut called the Financial Accounting Standards Boards. They promulgate standards. Those standards are promulgated through initial drafts. They seek responses from the affected communities. They may or may not revise. They then implement. Failure to comply with FASB standards, which are predicated on what are known as GAAP, Generally Accepted Accounting Principles, means that an institution will receive a qualified audit. In other words, they won't get a clean audit at the end of the year. That can have potentially serious effect on the museum community or the museum within the community. At the moment, as we'll talk about later, FASB standards explicitly limit application of the proceeds of sale from deaccessions to acquisition of new collections items except for living collections, i.e. in aquaria and zoos. That has been the situation now for, 20-some years, and it was a hard-fought battle to get FASB to understand what museums are, what their collections represent, and how we function with them. I think I'll leave it at that and come back to the problems of this intersection between accounting rules and deaccessioning later in the
Great. Thank you very much. Finally, we have Mark Gold. He's been a pleasure to work with in organizing this session. He's knowledgeable, responsible, thoughtful. He's partner Smith at Smith, Green, and Gold, undergraduate degree in economics, international studies from the American University, law degree from Georgetown University, master's degree, museum studies from Harvard. His work focuses on nonprofit and museum law. He is legal counsel to the Berkshire Museum, Pittsfield, Massachusetts. He's author of multiple articles on the use of proceeds from deaccessioning. He's a frequent speaker on professional panels addressing deaccessioning. He asks difficult questions of the museum field. He has a realistic approach and a solid understanding of the issues. Mark, would you please take a few minutes to give us some of your thoughts?
And I want to thank Suzanne for organizing this, and I am flattered to be on a panel with two real experts, so it's good to be here. You're going to hear some things today that I think you will find new and perhaps you'll find disturbing. I hope you do, because that's what challenges are all about. And you'll hear about how the rule on the use of proceeds came into being not to protect collections, but as Stephen just referenced, to protect museums from having to report the value of their collections on their financial statements. So it's been clothed in the sanctity of collections, but it is really about avoiding transparency, that museums kind of hold themselves out as the keepers of transparency and accountability. You'll also hear how the strict application of the rule, because it really wasn't based on collections, can result in some real absurdities and things that none of us in the room would consider unethical at all. So I'm challenge you to not just, to sort of hit a reset, suspend your judgment and saying, this is great, this is what, this is a rock solid ethical rule that I've heard about forever. And we'll just take a moment and peek and see what's under the rock, and then you can make your decisions again. The other thing I would like you to suspend is the demonization of boards of trustees. Every time something goes wrong in a museum professionals say, the board's been asleep at the wheel, they've mismanaged, whatever. It's not, gee, we've had lousy programming, that exhibition really didn't work out well. It's the board's responsibility. I've seen dozens of boards, I've been on dozens of nonprofit boards. These are good people, generally not just working for free, but contributing money, who care deeply about the mission and the institution and its sustainability and viability, just like you. Finally, just a quick other thing I'd like you to keep in mind, and that is the difference between deaccessioning and the use of proceeds. Deaccessioning is just fine. So, and these are often conflated, and I think we need to separate them. We're going to be talking about the use of proceeds. Certainly when you deaccession for a use that's prohibited, like Berkshire or Delaware or LaSalle or Randolph, that's a different issue. But let's look at what proceeds can be used for, because that is what the ethical rule is about, and not whether deaccessioning is good or bad.
Great, thank you very much. As moderator, I have a few questions to start the discussion. Each panelist has an opportunity to respond or provide comments. After my questions, I will ask for questions from the audience, so please be thinking during our discussion. I'm going to start with John and ask him this. Do the fiduciary duties of a museum's governing board lie first with its museum, the community that it serves, or the broader community of museums? Is there a balance? What's the obligation of these leaders?
Thank you, Suzanne. Most museums in the United States are nonprofit, tax-exempt organizations that carry out their missions for the benefit of the public. Because most museum property is held for charitable purposes, museums are legally treated as charitable trusts, which is why we say that a museum holds its collections in the public trust. This special status is defined and regulated by the Internal Revenue Code of the United States, and it means that museums have both legally mandated and implied responsibilities, including the duty to properly care for and manage their collections. The nonprofit public trust status of museums should not be taken lightly. In 2011, the Internal Revenue Service revoked the tax-exempt status of 275,000 organizations, including several museums, because they failed to comply with their legal requirements, including filing required reports. As attorney and museum director, the late Stephen Weil pointed out many years ago, nonprofits are given their special legal status to allow them to take on tasks that are socially desirable, and because they provide a benefit to the public. He also pointed out that nonprofit cultural institutions typically operate at the very limit of their resources, while providing what he phrased as a public benefit through their aspirations to excellence, their autonomy, and their diversity, unquote. Holding collections in the public trust does not mean that a museum must keep every object in its collection, but rather it means that a museum must ensure that the objects are used to help fulfill its mission and that the collection objects are not treated as a source of ready cash. Collections are the heart of the museum. Everything that a museum does, including exhibitions, public programs, research, the acquisition of more objects, all this is based on the collection. In her 2014 book, Museum Law, A Guide for Officers, Directors, and Counsel, Marilyn Phelan put it this way, quote, "While a private trust must have definite beneficiaries, the essence of a charitable trust is the indefiniteness of its beneficiaries. The public, whether limited to a few or the public in general, is the beneficiary of a public trust," unquote. The concept we know as the public trust is derived from this principle, and it's an ancient common law principle dating back to the time of the Roman Emperor Justinian, that recognizes that certain resources are important enough to be held in common for the benefit of everyone. Phelan also wrote that trustees and directors of nonprofit organizations are fiduciaries. As such, they must act in good faith and display complete loyalty to the interest of their beneficiaries, in this instance, the public. And concerning deaccessioning, Phelan also pointed out that the decision to deaccession vests a great deal of discretion in a museum's trustees. The trustees must consider the ultimate effect of deaccessioning upon the collection as a whole, as the entire collection is dedicated to the public benefit. It's important to keep in mind that museums and businesses play by different rules, and for very good reasons. It's the task of a business to earn a profit to make money for its owners, which is why for-profit museums treat the objects in their collections as financial assets to be bought and sold for the benefit of the owners of the business. But by contrast, it's the task of a nonprofit museum to use its collection to fulfill its mission for the public good, which means managing and caring for its collections for the benefit of the public. As museum professionals, our first duty must be to uphold the integrity of our profession. This means not just obeying the law, but adhering to a standard of behavior above the law. Without that, what we do in our museums and our institutions themselves will rapidly become devalued.
Very briefly, we could have comments from Mark and Stephen, if you like.
Okay. With all due respect, I think the question is really, what is the duty of a museum's governing board? To whom does it owe its fiduciary duty? I agree there is one, but any iteration that you see legally is going to be the duty of due care and the duty of obedience. These people, who are generally volunteers, owe their undiluted duty to the institution, to the museum. And it is not to the collection, it's not to AAM, it's not to the museum community, it is to the museum and the museum's mission. And this is what drives museum boards to make very, very hard and difficult decisions, to maybe sell an asset that they're legally entitled to, because their duty to the museum exceeds the duty to that object. That was articulated very well by Delaware. It's been articulated by Berkshire, that museums, I had one museum professional once say to me, what about museums that need to sell something to survive? And her response was, well, they deserve to die. They don't deserve to die. Museum boards are there to make sure they live. So let's make no mistake, it is not the community, it's not the broader community, it is that institution, and it's the survival of the mission, it's this protection of your jobs.
Great. Very briefly, we'll hear from Stephen, maybe a minute, please.
I would take issue with that. If the museum is in the form of a charitable trust, museums obtain one of two legal forms. Either they're operated as charitable trusts, the Getty, for example. In that case, then in fact, the primary duty of the Board of Trustees is to the beneficiaries of that trust, the general public, or a segment of the general public. It has, for more than 150 years, been deemed, certainly in codes of ethics, and now in at least one state by statute, that a museum in a not-for-profit corporate form that is also recognized as a charitable entity under state law and has achieved exempt status under federal law is deemed to serve as trustees for the benefit. So I would disagree with Mark and rephrase it that the duty of loyalty and the duty of care are the two primary duties. The duty of obedience is one that Daniel Kurtz came up with in the late 1990s. Not all not all scholars see it as a distinct duty. Most people subsume it under the duty of care, but certainly under the duty of loyalty. The duty of loyalty is to the institution as to all financial matters, and it is to the beneficiaries, the work of that, the beneficiaries of that institution to whom the ultimate duty is due.
Okay, all right. We're moving forward. This question first goes to Mark on public trust. What does the term public trust really mean? How is it used or misused within the museum community?
So I have a particular affection for the term public trust because it is used as, I don't want to say a dog whistle, but it kind of gets people's emotion going. And the essence of it is, well, public trust had its origin, and I'm sure these two gentlemen know much more about it, but I don't think it's all that relevant to get detailed. But the only place it really appears is in the law is in the concept of federal and state ownership or stewardship of waterways. You know, that these things cannot be owned by anybody, it's not personal property, they're for the benefit of everyone. It never appears in the museum context as a matter of law, except in the context maybe when someone's discussing it in an opinion or but there is no legal concept. And here's why. It's generally articulated that once an object falls under the aegis of a museum, it is held in the public trust to be accessible to present and future generations. And there's a concern expressed often that if objects are deaccessioned and sold, that donors won't give anymore because you've pulled these things out of the public trust. Does that sound like familiar? Okay, so think about this. And again, this is going back to my asking you to distinguish between deaccessioning and the use of proceeds. So when the Berkshire Museum sells things in its collection to ensure its survival, people have said that's a breach of the public trust because you're taking stuff out of your collection. You held it for the benefit of the public. It needs to be accessible, and now you're selling it. I was so pleased, not pleased really, but it was good timing that the Baltimore Museum of Art announced just recently that it's selling, I think, 7 paintings by 5 artists, including Rauschenberg and Warhol, no slouches. And what they're doing with the money is they're going to buy underrepresented contemporary artists. Good purpose. Not any better or worse than the Berkshire Museum staying in business. But the result is the same from the public trust perspective. These paintings by Warhol and Rauschenberg and 3 artists are no longer accessible to the public, and they'll probably go into the private collection somewhere. So if public trust really exists, challenge yourself to think about how that result in terms of this art being in the public trust is different from the Baltimore Museum to the Berkshire Museum. The net result is exactly the same. All we're talking about is the use of proceeds. And public trust is, and I have documents from AAM, this is a breach of the public trust, no one will give anymore. Well, why would they give to Baltimore Museum of Art if they know that their paintings might be sold for an albeit more worthy purpose?
Okay, briefly, John or Stephen, would you like to respond in a minute or two?
Yeah, just very quickly, the term public trust is a difficult term, and it has, to me at least, 4 separate meanings. A public trust is another way of saying a charitable trust. A charitable trust is established by a donor, transferring property to trustees who then hold that property for the benefit of the general public. That is a public trust. There is the public trust doctrine, which developed in the field of environmental law, largely through the efforts of a scholar out west named Joe Sachs, who at the end of his life wrote a very interesting book, Playing Darts with Rembrandt, taking a line out of one of Stephen Weil's essays, where he attempted to take some of his learning of the public trust doctrine in the context of environmental law and transfer it into this realm of cultural property. There's another definition which is used, the public's trust, meaning confidence in the institution. And finally, there are statutes that define it. New York statute states as follows: public trust means the responsibility of institutions to carry out activities and hold their assets in trust for public benefit. That statute also limits applications of deaccessions to new acquisitions or direct care, but that's not particularly helpful in understanding public trust. So particularly when journalists use this term, one has to look very carefully at which of these definitions is being used and to understand it's a very complex term with a long history and with nuanced meanings.
Any comment, Brim?
As the only one here on the panel who is not an attorney, I will defer to the conflicting legal definitions from my two colleagues.
Get him on Trivial Pursuit, I'm telling you, he's smart. Okay. All right, thank you very much. Moving on to accounting standards. Woo-hoo. If museums continue to monetize collection, is there a risk that financial accounting standards would change its favorable treatment of museums with regard to the capitalization of their collections and recording of their gift values on their income statements? And this one gets to go to Stephen, and Stephen, you can give us a little background on these standards as well.
Sure. The Financial Accounting Standards Board promulgated a exposure draft in 1990 that would apply to all nonprofits. And the exposure draft would change generally accepted accounting principles for nonprofits. For all nonprofits, it would require that nonprofits recognize as revenue the value of any gifts, contributions received during a year. And as to museums, it required the capitalization of their past, present, and future collections. What does that mean? It would mean assigning a value to the entire collection and carrying that value on the balance sheet. This was the museum community pushed back very hard for a number of reasons. First of all, it would be impossible to accomplish in most museums. It would be exorbitantly expensive, and far more importantly, any number that came up would be much worse than a guesstimate. It wasn't clear what roll blockage discount would take. It wasn't clear what an object is. And at first, FASB said you must value it at historical cost or fair market value at time of acquisition, and later modified and said, well, you can give fair market value as of today. Regardless, just think about your museum having to ascribe a value to every object. More importantly, completely, sorry? Oh, more importantly, it completely misunderstood what museums do, are, and what the value of their collections truly is. Museum community pushed back. There were hearings held, there were letters submitted, and FASB relented. And in its final statement, known as FASB 116, it has a new number now, that came out in 1993, FASB continued to urge museums to capitalize, but created an exception for collections items, and I quote, held for public exhibition, education, or research in furtherance of public service. FASB concluded, quote, contributions of works of art, historical treasures, and similar assets need not be recognized as revenues and capitalized if the donated items are added to collections held for public exhibition, education, or research in furtherance of public service rather than financial gain, i.e., these are not saleable objects. And in its conclusion, it states very clearly that their conclusion is, quote, based on the AAM's Code of Ethics for Museums and its 1989 accreditation self-study. It says the definitions in those documents are widely used by organizations for which FASB believes the relevant cost and benefit problem of capitalization exists. FASB decided that having an organizational policy that requires the proceeds from collection items sold to be used to acquire other items for collections demonstrates a commitment and a probability that the collections will and can be maintained. FASB believes that commitment is particularly relevant to its considerations about both benefits and costs of providing information about those assets. Do I have 1 minute left? No. 1 minute, real fast.
Yes,
okay, I'm sorry. To meet FASB's definition, there were 3 elements. A museum's collection must be held for public exhibition, education, or research in furtherance of public service rather than financial gain. They must be protected, kept unencumbered, cared for, and preserved, and they must be subject to an organizational policy that requires the proceeds of items that are sold to be used to acquire other items for the collections. So I'm a little bit baffled by Mark's earlier comment that AAM's policy, the AAM's policy went in that direction when FASB is saying that it modeled its language on AAM's.
Great, and now you can have a comment, Mark or John, briefly.
So this is the answer. This is a letter from AAM to the Financial Accounting Standards Boards proposing the footnote, how this should be handled. So I apologize, I'm kind of a plain speaker, and I just sort of cut to the chase, and I'm not very tactful, and I don't spend a lot of time ramping things up. But the reality is, until there was no, the use of the rule on the deaccessioning proceeds did not exist in 1970s. It didn't exist in the 60s. It didn't exist in the 70s. This rule is tied to FASB's effort to have museums report their collections at fair market value.
It first came out in 1978 as part of the accreditation.
Right, but, okay. All right. Well, if you believe that, I mean, look for your, honestly, when, all right, it is inextricably tied. There's a letter. Yeah, and, all right, let me just find one more letter I will read to you.
See, normally fancy lawyers, I'm a law professor. I'm not used to having somebody, but real litigators have an assistant sitting right next to an associate finding documents. So it's,
I'm not a lawyer, but I do play one on TV.
Right, and you could be a great assistant if you just knew what we were doing. This is a letter dated August 23, 2017 from Lori Fogarty at AAMD and Laura Lott from AAM to the Berkshire Museum. And let me read you her language. The principle, this is the principle about the use of deaccessioning, also serves as the basis on which our organizations were able to reach consensus with FASB many years ago, which allows collections not to be listed as assets on financial statement, a convention we assume your institution adopted. Whether a museum decides to sell collection items and use the proceeds for operations, all museums are at risk that works of art and other collections items will be required to be listed as assets. So if I made the mistake, I assume Laura did also. These are, and let's leave it at they're just tied together so closely, and that is, and actually, AAM hasn't been saying this until very recently. They've not gone out on and said, this is the reason for the rule. It's always been, it's the sanctity of collections. You can't, we want collections to be preserved. It's always been about accounting. And, I'm a little bit, to have, and I won't take much more of the time, but to have but I think the debate is fascinating, actually. To have museums say, gee, we wouldn't want to tell you how much our collection is worth because that would be really hard to do. It would be hard, but that doesn't mean the transparency, accountability is not worth it. And I just, there's a little bit of hypocrisy going on here that I think disillusioned me with the museum community. This was about, if people looked at what your collections were worth, they would say, why should I give anymore? You have all of this value. Totally an appropriate response, but then say that. Don't say it about saving collections, it's about turning our donors off.
one other just point is 1994, AAM altered the permitted uses of proceeds of sales to include direct care of collections, which was finally 12 years later in 2016, longer than that, right? 24, yeah, elucidated in the report on the Commission on Direct Care. And so since 1994, in fact, AAM's Code of Ethics has not been aligned with FASB's rules. And one would think that if, in fact, FASB had been predicating its statements on AAM, it's now had 20 years to reflect that change in the Code of Ethics.
Right, which very impressive commentators such as, who is the woman who just, I'm sorry, I've lost her name.
Lori Breslauer and Sarah Edel.
Right, have just published a statement saying, it's been kind of, and I think
These are in our resources at the end of the session as well.
It's been kind of a don't ask, don't tell. FASB hasn't caught up with the AAM, and it's still going along okay under the radar that museums are not having to capitalize, even if they're using it for direct care. And that Lori has very importantly said, let's bring them together. Let's bring them into alignment so at least we're consistent. But to say that AAM hasn't, or FASB hasn't done that for 20 years is not an argument that it is intentional.
Okay. Well, with all this now, we'd like to turn to you, and I know there's some experts out there as well, and we'd like to have questions from you. If you'd like to raise your hand, we'll have someone come in and bring you the microphone, and you can ask a question. We have a microphone here. Thank you. We've got, assistants. Thank you, thank you. Okay. Yes. Thank you very much. And actually, we'd like to make sure that if you'd please ask a question rather than give us a long comment, if preferably. Thank you very much.
So,
Please, why don't you do that?
I'm Erin Richardson. I have a long history in the museum field, but I just exited the field to become a private consultant. And first of all, I just want to thank you for your rational and professional viewpoints. I've been to many deaccession sessions. This is fantastic. I don't feel like a pariah anymore because I've said all of the things that you've said in the past. My question for you is, how can the museum field do a better job at articulating the definitions of some of these terms that you have mentioned today? Because one of our problems as a field is that we are terrible at telling people what these words mean. We are terrible at defining public trust. We are terrible at articulating deaccession as a separate thing from use of proceeds from deaccession. So are there instances or what guidance can you give us as professionals when we're speaking to the public that can help separate the different meanings of these words?
There are resources that are very helpful. There's Malaro and DeAngelis, the legal primer on managing museum collections, I think does a very good job of defining the terms. There's Marilyn Phelan's book I mentioned. There's also Heather Curavilla's legal dictionary for museum professionals, which is extremely useful in explaining those terms. So I think there are actually good resources and good definitions there. Can you tell us maybe why you find those definitions that are in existence inadequate?
I don't find them inadequate at all. I know what all the terms mean, but
It's a case more of articulating these to the public?
It's a public relations issue
It's like a quick elevator speech that you need to tell someone kind of sometimes.
Yeah, so it's a public relations issue for museums, so that we need, as a field, to do a better job of being vocal when someone, or especially a newspaper, says, deaccessions, blah, 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 horror. You know, how can we step in and say, no, you've misconstrued what this means. Deaccession does not mean sell the collection. It means something else.
I think that's an excellent question, and I've been particularly I think the answer to that is to, when you're asked the question, to be honest about the answer. And, you know, to stop using public trust as a dog whistle. When we, at the Berkshire Museum, when we were deaccessioning a Rockwell, the only bit of evidence that there was any, there is no evidence of restriction, but there was a letter from the executive director of the Rockwell Museum, or the Berkshire Museum at the time, saying, we are taking this painting, thank you, we're putting it in the permanent collection. Now, everyone in this room knows what permanent collection means and that you deaccession from the permanent collection. We had museum professionals sit quietly while the public and some government officials assumed that that meant you couldn't sell it. So please, you know, you do harm to yourselves when you take a position that you know to be wrong because of the outcome that you wish for. So treat public trust for what it is, and treat permanent collection for what it is, and explain deaccessioning that it is okay. So I agree with you, and I think, but I would start by being honest instead of using it, and we're advocates, I advocate by the use of language, and the museum community does too, but when I'm expected to, because I'm a lawyer, you're expected to have integrity.
Just add one minor point to that, which is a great deal of the confusion here comes from media reports. And sadly, a program that I was funding when I was at the Pew Charitable Trusts with the Knight Foundation, the National Arts Journalism Program, which sought to improve the quality of arts journalism in the country, ended up getting defunded when Pew canceled out their National Culture Program. We need to make more efforts with the media. I get calls from reporters all the time, and I no longer will talk on the record because I see my role as an educational one. Same things if they're in the classroom. If they don't want real background, if they don't want me sending them articles, then I don't want to talk with them either, right? But I do what I can my own little way, and some of you, when you're contacted by the media, make sure they're using their terminology correctly. I think that is an important way that we can directly affect what the public sees and how the media reports it.
Okay, thank you.
Hi there, Lori Fogarty, Director of the Oakland Museum of California and current President of AAMD. I have two questions. One is about museums. Our museum collection of almost 2 million objects and artifacts and specimens is owned by the City of Oakland. And so the issues around city or university-owned collections and the responsibility of, in our case, our city council. Luckily, we do have collection policies, AAMD-sanctioned collection policies that our city council has passed. But there, the obligation of the governing entity is quite different. And secondly, if you could speak to the whole process, deaccessioning, as we've said, is different than utilization of funds. But the deaccession process itself, taking into account curatorial selection, donor intent, the broad process itself before it even gets to utilization of the funds, if you could speak to the ethical aspects of that process. Thank you.
Could you come and autograph my notebook first?
If you'll autograph my program.
Well, I think there is good guidance on what those for the ethical issues, and I think the problem is, as our first speaker indicated, we're not doing a good, or our first audience member indicated, we're not doing a good job of articulating it. But I think a little transparency is in order, and museums should be more forthcoming about the importance of deaccessioning. And deaccessioning is a tool that is used to help you keep your collection and help you manage your collection. It should be in your policies. In my opinion, your collection management policies should be posted on your museum's website. They should be available to reporters and to the public, and they should be written in clear, simple language. So I think there are means to do that, and I think many museums have done a good job of that, others not so good.
A good example is when Max Anderson was director at Indianapolis, started a component in the website, which is still up and still running, which identifies every object that institution has deaccessioned, how it was deaccessioned, what the price received was, and what the proceeds of sale were used to acquire. That kind of transparency and accountability, I think, would go a long way to helping demystify this process.
Yeah, I think a key part of Lori's question was, what about where you have parent organizations instead of a freestanding museum, where you have a college or university, or you have a municipality or the Park Service or whatever. I think that's really important because it goes back to our discussion on fiduciary duty, because now you have a board of trustee of a university, let's say, not a museum. So they're looking at the museum and its collection as an academic, a scholarly tool, an academic tool, somewhere within how does it fit in with the mission of education. And I think that explains why a lot of these controversial deaccessioning cases actually involve universities instead of freestanding museums. Randolph, LaSalle, Fisk, yeah, and Brandeis for a moment, because their trustees have going back to that, their duty is to the university, not to the museum. So I appreciate that question. It was in my notes and I forgot to say it, but there's a big distinction when you have a parent organization.
Okay, all right, thank you. Next.
My name is Diane Didamore, and I'm a curator at the Arizona State Museum at the University of Arizona in Tucson. And I'm just wondering if you've been involved in discussions that have to do with history museums, with natural museums that are very different from art museums. I mean, I am shocked at the idea that I'm not being transparent because I cannot honestly imagine being able to appraise the kind of collections that we have, and it's not because of hypocrisy, anything, it's just pure fact of the number of things we have and the almost impossibility of even providing monetary appraisals for antiquities particularly. And so how do these things like play out beyond the major art museums and into, you know, smaller cultural organizations and history and all?
I think if we got to that point and there was some discussion of it back at the time, there would be protocols for doing that. No one expects a museum to get an appraisal on every single object. So you appraise by category. I mean, you appraise for insurance purposes. You're able to do that.
Well,
Maybe you
when
don't.
things go out on loan, but otherwise we don't.
But, I mean, you're not appraising the entire collection. You're getting coverage based on some percentage of. I'm just saying there are ways to do it. It is not intended that you have to count everything in order to do that. And there would be protocols for doing it. There just aren't any right now. The other important thing is that, and we can get back to this with FASB, it applies to the individual offending museum. It's not field-wide. So if Berkshire Museum breaches this protocol, then it will be required to capitalize its collections on its balance sheet or have a qualified opinion. But you're not required to do that, which is one of the mysteries to me that we'll get to later on, is if this just lands on the offending museum, why are the rest of us, you know, I mean, we're just shining a bright light on this offense and almost challenging FASB to do something about it instead of laying low.
I might point out that establishing value for history collection is easy compared to natural history.
I was about to make that same comment. And also, again, you know, you let sleeping bears lie. And the more FASB sees museums transforming their collections items from educational and charitable use to financial use, the more likely it is that they may decide they need to revise again. And I don't think right now the museum community, given the other political challenges we face, really is in a position to have to fight that battle from 30 years ago again.
Could I just respond really quickly?
Yes, briefly.
So I think that's fascinating. The question at the end is, what would we have AAM do? And I think you're absolutely right. And what scares me about going full bore on offending museums is you are invited. So first of all, I don't think a board of trustees, I know boards of trustees are not going to look at the AAM standard and say, uh-oh, if we do this, we have to do to survive, then FASB may take an interest in the whole rest of the museum community. So by coming down hard on these institutions, you're not changing the outcome of their decision. What you're doing is shining a bright light, and almost every letter to the editor, every editorial, every press thing said, and it's a violation of AAM's ethical rule. So the press does its share to keep the conversation going. But I would say you're absolutely right, which is why I would not come out full bore in sanctioning and threatening and doing all of these things to get the Berkshire Museum and its like to change its mind, because they're not going to, but they will have the effect you have on FASB.
I think it's fundamental to everybody in this room that transparency and accountability are the fundamental hallmarks of the charitable nonprofit sector, and I really do question whether the correct question was asked, which is the survival of this institution. All of us know of many very successful mergers. We know of some successful dissolutions. And one more thing about deaccessioning for proceeds to be used for something other than direct care or acquisitions is it doesn't work. I know, and I would be very happy to hear from anybody who does, I know of only 2 museums that have ever deaccessioned either to pay debt or to pay for operating needs that have long-term survived. And that is New York Historical Society and its deaccessions in the 1990s, and the Shelburne Museum and its deaccessions. There may be others, I just don't know of them. So from my position, regardless of FASB, it's not a tactic, a strategy that has shown success.
Okay, 10 seconds.
Stephen,
and
do
then
you
we're
know of
gonna
any
do
of any who have died?
Okay, we will move to the next question. Okay.
Thank you. I'm Sean Blinn. I have been a professional. I've been a consultant. I've even been a trustee, and I've served on local and county government commissions about historic preservation and culture. So I wear a lot of different hats, and I've worked with a bunch of historic house museums, which is where my question specifically goes, which is some things I have read say that it is acceptable to accession, given that the house in many historic house museum cases is the most valuable quote-unquote object in the collection, that it could be acceptable to accession the house into the permanent collection. So therefore, selling any objects from the collection, from deaccessions and use of proceeds, could then be used for maintenance on the quote-unquote collection, which is the house itself. So I wonder what your thoughts are on that, if you think it's acceptable, if you think it's unacceptable, and if there's any specific cases where it could be either way.
There's obviously other factors would be involved in that too, considering the house, the age of the house, the role of the house as the historic site. But if you go back to the white paper that was issued by AAM, and you look at the matrix there, I think you could probably answer that question pretty easily with that matrix. I think it's been extremely useful. But it's going to be, you need to look at this case by case. But I think that the work on that white paper was extremely good in giving museums guidance to make those decisions.
Great. Okay. Also seeing that in our bibliography. So next, please. Thank you.
Hi, good morning. Thanks for being with us. My name is Robert Stein. I'm the Executive Vice President at the American Alliance of Museums. I'm also the creator of the Deaccessioning dashboard at the Indianapolis Museum of Art, and we did a similar project at the Dallas Museum of Art. But I'd like to correct two facts that were presented this morning, and then end up with a question. So the first is really that to point out that to link exclusively AAM's communication on deaccessioning to FASB's standards of valuation is certainly an issue that we feel is really important, but is not the only one that we communicated as a reason not to deaccession these works of art. I think we've talked about many of those other ones, and FASB standards are certainly important, but I'd like to reject the notion that FASB's standards and release from valuation of the collection is in some way linked to lack of transparency. It's in fact a recognition that the valuation of specifically works of art is inherently difficult to pin down and is perhaps not even linked to the true purpose. The second, the question is really one of, we talked about board's duty, and we mentioned donor intent only briefly, but I'd love the board or the panel to comment a little bit on a board's duty related to charitable purpose. So especially nonprofit organizations in the United States, museums in this case are organized around a charitable purpose, which in many cases equates to doing public good. That charitable purpose is the way in which nonprofit benefits are accrued on the organization. And the board's purpose, as I understand it, is to uphold that charitable purpose in the nonprofit sense. So I'd love the panel to comment a little bit on how that charitable purpose intersects with respect for donor intent in the case of collections.
Okay, I think both of those are important questions, and you don't get to deaccession and sell things if it's contrary to donor-imposed restrictions. So and the courts are pretty clear about this, that you have to prove a restriction, and if it's not, then you're free to deaccession it. So to say, gee, I think Norman Rockwell really would have liked this to stay in Pittsfield so everyone could see it, you can't infer that. I mean, you might be able to infer it from, maybe I talked to him 40 years ago, but you can't be selling anything. When I talked to the AG's office when Brandeis was considering the sale of the Rose, and I said, what are your concerns? And the assistant AG who was handling it said, we look to see if there are any restrictions. If there aren't any, the board can do what it wants and exercise its fiduciary duty. So your question about the charitable purpose, I was really pleased by watching Laura Lott's speech yesterday, because she tied museums to the education, especially in K through 12. So nowhere in Berkshire County, and which has some extraordinary museums in the Berkshires, is there any museum that is more closely tied to K through 12 curriculum than the Berkshire Museum. And that is why the board of the Berkshire Museum, to your point, said our charitable purpose is that part of our community. They did, and I won't justify what they did, but they did a 2-year study asking the community what it wanted. And then they decided that in order to fulfill that purpose that you referred to, they did not need a Norman Rockwell painting that had a value of $20 to $30 million for action purposes. So that's what they do. Thank you for saying that. That's exactly what boards do.
Well, I would go back to Millar and DeAngelis' legal primer on managing museum collections, and their definition says, essentially, a trust is a fiduciary relationship whereby a party, known as a trustee, holds property that must be administered for the benefit of others, known as the beneficiaries. Those beneficiaries are the public. I believe that obligation is not necessarily to the museum itself, but to the public that the museum is serving. That is the purpose of the museum. That same reference also says a trustee also has a duty to be obedient to the terms of the trust. This requires faithfully carrying out the terms of the trust, and of course, part of that trust is we have missions, and those missions relate to our service to the public.
Okay, and then one quick comment from Stephen.
Yeah, and there's some very interesting work in the nonprofit sector going on right now that is taking charitable purpose as a starting point, but is focusing now much more on creating public benefit for charitable class. For many years, the rubrics under which we analyzed why is there charitable tax exemption, and it was the non-distribution constraint, because these organizations can't return profit to shareholders. More recent writing is pointing in another direction, which is the justification for charitable nonprofits is that they create public benefit for a charitable class. And so you have a charitable purpose that is carried out with your charitable activities, directed at a charitable class to create public benefit for them. So charitable purpose becomes a part of that sequencing.
Okay, next question, please.
Hi, and I also want to thank you all for doing this panel. It's been extremely useful and thought-provoking. My name is Barbara Hanson Forsyth, and I'm our Senior Manager of Collections at the Mingay International Museum in San Diego. And we are a museum that actually, since it was founded in the 70s, has treated its collection as an asset. And in the past few years, I have been actively deaccessioning, with all the proceeds going back into the acquisitions fund and direct care. Now, there's been a few hundred works that we have deaccessioned, but a very little monetary value because these were things that came into the collection, and this is kind of more a comment on that I was curious for Mark, when this discussion of putting your collections on the books would deter donors, the explanation I've always gotten for why we put our collections on the books, because I've been very upset about it. I've been trying to advocate to change that because it makes me uncomfortable. But the explanation I got was when our founder, who has now passed, formed the museum, she thought it would attract donors to look like we had already a good base. So if the collection was on the books, then it would look like, it'd augment our worth. So anyway, what happened was we just took, it became basically like a donations factory, right? And so the material that I'm parting with is material that probably should never have come into the collection in the first place, and it's not fetching much money, but the reason we're doing it is to create more room in our collections to properly care for things, not because we're going to get money from it really, but just so that we can get care of our stuff. But I guess my question is this transparency, maybe I'm barking up the wrong tree trying to change, the repercussions of trying to take it off the books would also, collectively, it's a big, it's a big collection. So even if individually the things don't have much value, if we were to take it off the books, that's a non-starter. They're not
Okay.
entertaining it. So I'm just
Can
curious.
one of you guys respond to that one, please?
I think you need to make it clear to your public that the reason you're deaccessioning is to take better care of the things in your collection already. You can't take care of everything. And, there's a really nice book on sale this week in the bookshop that points out the best deaccessioning policy is a really good accessioning policy.
I got to get that one. Okay, we're going to have just a couple more questions briefly because we have a final question for our panelists, so we'll get last two quickly.
My name's Hillary York, and I'm the collections manager for the National Numismatic Collection at the Smithsonian. And my question was if any of you have any thoughts on deaccessioning large groups of similar objects that may have a significant impact on a collecting community by flooding the market for them, and the concerns of some of these communities, and similar to the Postal Museum's large deaccessioning.
This is a good reason to separate your deaccessioning policies from your disposal policies, because you're deaccessioning these because you want to take better care of the collection. The disposal is another issue, and the way the disposal of an object is going to affect market value is important. For instance, do you leave a registration number on it or not? Does the fact that it formerly belonged to your museum affect the value of those objects? We can all look at examples of the reverse of how collecting affected museums. The growth of the museum, and I forget the name of it, in Arkansas, American Art Museum, Crystal Bridges, greatly affected the price of American art because the people establishing that museum had very deep pockets. So, both acquisition and deaccessioning, or disposal of objects, can affect it, but we really do need to separate deaccessioning, which we do for the better care of the collection, from disposal, which then generates those proceeds, which is the subject of our controversy today.
There are special rules, for example, in deaccessioning work of living artists, where our ethical codes give us some special guidance. I've not heard your question before, which is, would a block of similar items into the numismatic community negatively affect other collectors? And if so, what should we do about it? If it might, then it would also mean that you would get less money for your sales. And if you depend on those donors to be generous to you for operating funds and gifts of objects, you might look at the guidelines for deaccessioning of works of living artists to see if you might learn something from that context that would be relevant to collectors in this narrow field. It's a great essay question for museum law class.
And I am sorry, we're going to have to stop with that audience question and move to our concluding question. But I wanted to let you know that these gentlemen are available after this session and would be willing to talk with you. Very nice gentlemen, so be sure to meet up with them right after. Our concluding question is this. What would each of you advise AAM and the museum community do about the continuing controversy surrounding deaccessioning and the disposal of museum collections? And I believe we've got John going first.
Well, the first thing I would say is be clear, be transparent, and be honest. You've got to be forthright. We also need to remember ethics are regularly reviewed and revised to help us better fulfill our mission. Ethics are not set in stone, and these things change, and they change for very good purpose. We obey the law because we have to. We follow our ethical standards because we choose to, and I think that is extremely important in this discussion. Our ethical standards as museum professionals are critically important to the integrity of our profession and our institutions, and because these are reviewed and revised regularly, they do reflect the consensus of the profession. So if I can do another quote, this is from Heather Curavilla in her book, A Legal Dictionary for Museum Professionals. The legal system sets a different standard for conduct than ethics. In general, the law is intended to require conduct that allows us to live in society without undue harassment. It permits us to live our lives and interact with others in a manner that leaves us mostly unmolested and unharmed. Seen in this light, the law sets a fairly low bar for conduct. In comparison, ethics sets forth the conduct that a profession considers essential in order to uphold the integrity of the profession. This is a higher hurdle, demanding behavior that is above and beyond what is required by law, unquote. So if we abandon our ethical standards concerning the use of proceeds for collections for the expediency of an easy solution to economic desires or economic problems, we will also abandon our integrity as museum professionals, and this will damage the public's perception of our institutions.
Thank you. Okay, next, Stephen, would you like to respond to this question?
I would, in this way. The first AAM Code of Ethics was written in 1925 and wasn't revised till 1978. And the 1925 doctrine was aimed at, quote, museum workers. Since I've been involved in the field starting in the early 70s, I think one of the great steps forward that the museum community has taken is to professionalize itself and to attain a level of competency and of mutual respect for our different components within the museum communities, and respect from the public as well. We have become a profession, and professions, take lawyers for example, have rules, and those are ethical rules, and the violation of ethical rules as a lawyer, violating the professional rules, violating the rules of professional conduct, leads to sanction. And professions do this. Physicians do it, dentists do it, lawyers do it, and we're a very young profession. And I think we need to consider that the public considers a profession an organization of people working in a similar field with basic credential requirements and with ethical codes that need to be articulated, need to be clear, need to be well understood, and need to be enforced. So I would say continue with this evolutionary pattern. Yes, John, ethical codes must be revised on an ongoing basis. They will be, but any museum that strays from it is a museum that is potentially harming the rest of the museum community and itself. There are just too many good support systems among colleagues these days that didn't exist previously, and I'm all in favor of all efforts the museum community can make to continue its professionalization, to continue to work on its codes of ethics, to continue to communicate those not only to its own community, but to journalists and other media outlets as well as the general public directly.
Thank you.
I like you guys a lot, and I say this comment, but I feel a little bit like, I think it was the Ronald Reagan debate, where there you go again. No one disputes the value. No one disputes the value of ethics, and I think this is one of those things where, and I see see it too often at a national level. We're talking about this rule. We're not talking about ethics in general. And to say, and this rule has essentially been the same. It's not been revised. It's not been looked at because it complies with FASB. We have Glenn Lowry, the director, maybe you've heard of him, at Museum MoMA, has suggested that it be expanded to include programming. And guess what? When it includes programming, it includes the ability to hire people to do programs, to pay them fairly. I mean, I bet you most people here, and I've got an article coming out in 4 or 5 months about systemic undercompensation in the museum field. Well, guess what's one way of doing that? To turn the stuff into your basement into endowments to support staff. Larry Yurden, he's been on a national figure at executive director at Strawberry Bank, has proposed an asset for asset change in this rule. So you can't use it to pay the electric bill, but you could use it to create an endowment, move it from this asset to that asset. No one that I know of is studying this rule to see if it can be improved. So the quick answer, the question was really, what should AAM do? And for a number of years, and AAM's Museum Magazine published, to their credit, published some op-ed pieces from me many years ago complaining about this rule, highlighting how its origin. And I said, oh my God, I've been wringing my hands. How could this rule be fixed? And it has finally occurred to me, and I don't say this with any hostility, it really doesn't matter, because museums who feel that they're in trouble, boards that have looked at, and this is another common, there you go again, well, the board didn't think of raising money, the board didn't think of putting the money in themselves, they didn't do this, they didn't do that. They actually do those things. They have studies done, they have feasibility studies, they have experts come in and say there's no way out. So these boards are going to do what they need to do to support their mission. So AAM has 3 choices. They can keep the rule the way it is, and that's fine, and museums who need to do this are going to continue to do it, and FASB is going to continue to look at it and say, oh my God, this isn't working. They can keep the rule intact and stop making a high priority of beating up on museums that in good faith feel they need to do what is their ethical duty, is to keep the museum open. Or they can change the rule and work with FASB to say, okay, well, maybe we can expand it a little bit. How about asset to asset? How about endowments for programming and staff support? But at the end of the day, I think there are museums, I think the rule is working for those museums that consider it to be sacrosanct. But as soon as museums who are facing that know that it's not illegal to do this, they're going to do it to keep their museum alive. And I would just respond to one more thing Stephen said. And that, he said, well, I know of only 2 where it worked. Delaware is still open. Randolph University is still functioning. The jury is out on whether these things are working or not, but they're still alive. So to say that there are only 2 and Berkshire is going to be around for decades, these things actually do work.
I would point out that ethics are not rules, they're standards. And so we're not adhering to a rule, we're adhering to a standard. And that standard we're adhering to because we're professionals, and that has to do with the overall functioning of the museum. If the management of the museum, whether that's the fault of the director, the staff, or the board, has reached the point where it's so critical that you must sell part of the collection to stay alive, what guarantee do we have that that financial management's going to be better tomorrow once those collections are sold? How do we know that that museum isn't going to wind up in the same financial problems that it is now? Because this means they have also neglected other ethical standards. Those have to do with taking care of the collection and managing the institution properly.
All right, so when General Electric leaves the city of Pittsfield and takes all of its jobs, and SABIC leaves Pittsfield, and General Dynamics leaves Pittsfield, that is not board mismanagement. I'm sorry. And to say that because because the board may screw up 10 years from now is a good reason to shut the museum down now, rather than sell something to keep it alive. And one of the biggest piece of the Berkshire Museum's collection that was sold is going to be in the public domain in Los Angeles. So tell me how that is an ethical breach, where I don't know where the Baltimore Museum's paintings are going.
Okay, I think there are, we've got a couple more minutes. Anyone last comment, or we're done? Okay, all right. Okay, so as I said, these gentlemen are very much open for further conversations. We have put together a long list of selected resources here. We also have some online resources here, so you can access them as well. Another thing that we did, because we had a pretty extensive list of resources for this session, if you go to the Collection Stewardship website, and you can look under a tab on the bottom right under Deaccessioning, and there's a link right here, and you can see a 3-page list of references that were probably mentioned here in other documents as well. So thank you very much for attending our session. We know that during these times of concurrent sessions, you have a choice, so thank you for choosing this one.